Hello, my name is Jamie Barnett. I'm a retired admiral of the United States Navy and currently serving as the chair of the board of directors of the American College of National Security Leaders. The American College of National Security Leaders is a nonpartisan group of retired admirals, generals, and ambassadors to serve as a voice of experience on matters of national security. And the national security matter that we're bringing to you today is focused on what senior and mid-grade military officers and senior enlisted need to know about a Supreme Court case that was decided in the summer of 2024. That court case is Trump versus United States. And in that case, an indictment against President Trump was that he conspired to overturn the election by spreading knowingly false claims of election fraud. President Trump's counsel moved to dismiss the indictment based on presidential immunity, uh, arguing that a president has absolute immunity from criminal prosecution for actions performed within his official responsibilities. The district court denied Trump's motion to dismiss, holding the former presidents do not possess federal criminal immunity for any acts. The D.C. Circuit affirmed this decision and it went to the Supreme Court. And that case was decided in July of 2024. Now, to help understand what a ruling on presidential immunity has to do with military offers, and lawful orders, I've got some great Air Force officers to talk with us today. So sometimes you call in the cavalry. This time I'm calling in the Air Force. First, we have retired Air Force Major General Steve Lepper, a seasoned attorney and member of the Judge Advocate General Corps. He has many degrees, but I will mention that he holds a Juris Doctor degree from Duke University and a Master of Laws in International and Comparative Law from Georgetown University. Among other positions of great trust and authority, he served as Deputy Judge Advocate General of the Air Force, and you can read more about us on the ACNSL website. Also with me, retired Air Force Major General Andy Turley is also a distinguished attorney and member of the Judge Advocate General Corps. He's also been a member of the Senior Executive Service as the Civilian Deputy General Counsel of the Air Force for Fiscal, Ethics, and Administrative Law. Among many other positions of trust and authority, he served as the first General Counsel of the Joint IED Defeat Organization in the Department of Defense during a time when IEDs were in the news every day. So, generals, thank you so much for being with us. You can correct anything that I've said to this point, either about your bios or about the case. But maybe one of you could give us an idea of what the Supreme Court said.
Sure, I'll start, Jamie. And before I start, let me thank you for doing this. Where we are right now is a perfect time to discuss the impact of this decision on military orders because so much of what's being discussed as we run up to the election in a week and one day has to do with the use of the military by the president. And this case, although it doesn't talk specifically about it, at least in the dissenting opinions, it does talk about how the majority opinion could be used or abused to allow a president to use the military in ways that have never been done before, and that may be ways to further the personal objectives of a president. So just a little bit about the case itself. You described that this case came out of the DC Circuit as a result of an indictment that was handed down by a grand jury against former President Trump for actions that he took or in some cases didn't take on January 6th of 2021. And the important key of the case really is on page 6 of the opinion. If anyone has the opinion in front of them, they can take a look at it. And the court summed up its ruling, which essentially overruled both the district court and the DC Circuit Court of Appeals in one paragraph that really does the best job of capturing the scope of the opinion. I'll just quote it. It says, we conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. At least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official actions, he is also entitled to immunity. And then the court goes on to say that at the current stage of proceedings in this case, i.e. the January 6th case, however, we need not and do not decide whether that immunity must be absolute or instead whether a presumptive immunity is sufficient. So what the court basically does is it says the president is immune to some extent for his official acts. In some cases that immunity is absolute, those cases being the cases in which the president exercises his or her core constitutional powers. And then there's a presumption of immunity in all other cases where the president exercises official duties. In this particular case, or at least in the case that prompted Andy and me to write our op-ed, of course, having been in the military, having spent as many years as we did in the military, and particularly as judge advocates who advise commanders about what the difference between lawful and unlawful orders are, we were concerned that this opinion of where it basically talks about core constitutional powers, one of which we believe is the authority of the president as commander-in-chief, could at least confuse, if not totally change, the distinction between lawful and unlawful orders going forward. Now, Justices Sotomayor and Jackson, in their dissent, do talk about how the military might be used by a president to advance objectives that previous presidents had never considered. And the purpose of our op-ed was to at least point out areas in which contemporary legal thought might have gotten it wrong. And the one area where I believe that the large number of legal experts who have commented on this case may have gotten it wrong is their assumption that this immunity only extends to the president. You know, one of the concerns, and I'll point it out here in a little bit, that we have about this particular case is that the rationale on which it is based could extend that immunity to people who carry out the president's orders, not just the president him or herself. So we'll have an opportunity to talk a little bit more about that, but I'll pass it on to Andy to talk a little bit about our op-ed and the concerns that we had after this case was handed down.
And General Turley, if you could maybe just, because a lot of the people that will be watching this are not attorneys, maybe just revisit, what is a military member's responsibility to obey a lawful order?
The military member's responsibility is to obey a lawful order. The issue that is presented here is the military member also has a duty to disobey an unlawful order. And making that distinction is tremendously important. And this gets you to the point of a lawful versus an unlawful order. Most law orders we know are lawful. Some of the unlawful orders would be asking a military member to commit a criminal act, or to do something that is not consistent with their oath of office and their oath to the Constitution. So it's not just that they can that they have a duty to follow a lawful order. They have an affirmative duty to not obey an unlawful order. And if a president is immune, but nevertheless issues orders, and this is pointed out in both the Sotomayor and Justice Jackson dissents, that they can order the military to do virtually anything, and the president would not be subject to prosecution, but those who carried it out would be. And this gets to now the counter to that is, well, the president could just pardon the person for committing that crime. The case in point that Justice Sotomayor used was to send SEAL Team 6 to execute his political opponents. Clearly unlawful, and clearly something that, according to the decision, the president cannot be criminally held liable for. But the big issue is those who carry out those orders can be, and the fact that the counter to that would be, well, the president could just pardon them, but that doesn't do it. We're concerned about the next logical step the implications of this case roll out, is the fact that the scope of immunity may go, or the shield of immunity may go to all of those who carry out his unlawful orders, and that's a real issue. It's the logical next step.
It may not extend to those people too as well, and it wouldn't extend for state crimes. If murdering or shooting a rival is charged under the state, would the president be able to do anything about that?
The immunity would be criminal liability. But the people who carry it out would have criminal liability for their own particular actions, and that's the issue. But we're concerned about expanding the logic of expanding the scope of this immunity to include those who carry out those orders. For example, and I think this is what we point this out well in the op-ed, is that a president can sit in the Oval Office and issue an order, but the president does not carry out those orders. All those people around them carry out those orders, and those are the people that we are most concerned about.
Steve, how does a senior or mid-grade officer or senior enlisted make that decision? I mean, that sometimes it's pretty clear, murder these prisoners of war. Well, that's clearly illegal. But on this, go arrest all those people, or shoot the people that are protesting at some particular place. This gets on the edge of, well, should I do this or should I not?
Well, you're absolutely right. I mean, it's hard enough. It was hard enough before this decision was handed down to distinguish between a lawful and an unlawful order. As Andy said, there's a presumption whenever a senior officer gives an order, or all the way up to the president, when an order is given, the presumption is that it's a lawful order. And there aren't many military members who would presume the opposite. It takes a lot of frankly analysis by folks who served as judge advocates like we did to distinguish a lawful from an unlawful order. And when an individual airman, in our case in the Air Force, or an individual commander would come to us and ask us whether an order is lawful, it takes more than a few minutes for us to decide whether the order is lawful or unlawful in cases in the gray area. One perfect example of the way in which this case becomes really, really important is most orders require immediate execution. And let's remember back to General Milley when he was the chairman of the Joint Chiefs of Staff, when he was standing behind the cameras in Lafayette Square, when the president asked him to come up and join a photo op. And General Milley had to make a split-second decision. Do I do it or don't I? Well, he decided to join and regretted it and apologized the next day for it. Those are the kinds of orders, those are the kinds of situations where it's going to be very, very difficult, even more difficult now that this case has blurred the lines between lawful and unlawful order for a military member to actually decide, or a judge advocate to assist in the decision whether or not the order is lawful or unlawful.
And I suppose that, like so many of these cases in the past, you're making a decision about whether to do something unlawful, or you may be making a career-ending move or career-damaging move, and that's a tough place to put people. So, General Turley, I mean, what would your advice be to military officers, senior enlisted, that get presented with something that they think is questionable as to whether it's lawful or not?
I think they need to reach out to their judge advocates and not um, um, and avoid. And sometimes, as General Lepper points out, sometimes there's no time to do that, and sometimes they have to make a split decision. One of the great things about our military folks is they have a great sense of integrity, and they have a great sense of what's right and wrong, and what to do. And I think part of it, if they don't have legal help available, and we would hope that they would reach out to their judge advocates. We rely on their integrity, rely on that sense of right and wrong, because that's the way they've been brought up. They're focused on doing the right thing and then doing it right. So, I think it's going to take a lot of training, discussion, thinking about it. There have been a couple of articles written on it already to get military members to start to think about how they handle these particular situations. The bottom line is that we take an oath to the Constitution, and we do not take an oath to a person. And that is the key distinction. That's the whole basis of our Constitution. And I think people keeping those very simple things in mind will kind of help guide them as they work through this thicket.
Let me just add.
I think that's a brilliant way to say it. And I think one thing to remember is that our military is not designed to treat citizens of the United States as enemies. General Lepper, I give you the last word.
Well, let me just add to that. There are a couple of other aspects of this decision, and one of the things that General Turley just mentioned that makes this even more confusing. One is, while officers do take oaths to just the Constitution, the enlisted oath does require enlisted personnel to follow the orders of the President of the United States and all officers appointed over them. So that's a twist that a lot of folks who have commented on this case and its impact on military orders really haven't considered. The second issue here, and while General Turley is absolutely right, the president has pardon authority, which could extend by pardon the immunity that the president enjoys for his core constitutional acts beyond the Oval Office door. The one concern that I have, based on some language that I haven't seen really commented on by other legal commentators, is on page 8 and 9 of the opinion. It says that Congress cannot act on and courts cannot examine the president's actions on subjects within his conclusive and preclusive constitutional authority. It follows that an act of Congress, either a specific one targeted at the president or a generally applicable one, may not criminalize the president's actions within his exclusive constitutional power. The concern that we raised in our op-ed, mainly just as a question that we haven't been able to answer and probably won't be able to answer until the situations arise, is whether that language means that all orders of a president are lawful, simply because Congress may not make his acts unlawful. That language is very unclear when it comes to thinking about the impact of this decision on military orders, because it basically says that the president cannot be subject to the criminal law while he's exercising his core constitutional powers. And if that's true, does that impact the lawful versus unlawful nature of his orders? that I'm hoping that the Department of Defense is considering that in its efforts to create guidance based on this decision. My only concern is that everyone who's commented on this case up to now has simply assumed that the immunity will have no impact on the people who actually carry out the president's orders, and that an unlawful order remains an unlawful order, despite the fact that this decision confuses the two.
Well, I think that is the lesson I've learned from you two today is that this decision has made the interpretation of lawful order and obeying it a murky situation, one that people need to be aware of. Rule of thumb from General Turley is do the right thing. I'm going to post your op-ed from the South Florida Sun Sentinel, which I believe was on July 19th of this year. And we will continue to keep a focus on this area to make sure that military officers, senior enlisted, have the information they need. General Turley, General Lepper, thank you so much for your time and your insights today.
Thank you very much.
So